Good morning, everyone. In this course of Comprehensive Guide for Indian Patent System, the first module will be discussing about the patents introduction and definition. In this, the contents which we will be going on through is the introduction to the IPR and the definition of the patents and needs and benefits of the patents and Indian Patent Act and patentability criteria. So first of all, while moving on, what is meant by patents, just we shall see what is it meant by a tangible and intangible property. Actually, things are commonly recognized as a possessions of an individual group can be divided into either tangible or intangible. Tangible means which have a physical existence and intangible means which do not have a physical existence. For example, vehicles, plant, machinery, these all are tangible properties which we can feel them, we can see them. And then intangible properties means that is something like a software, like a logo and the patent. These all comes under the intangible properties. For tangible properties, we can define the cost. We can determine the cost of that easily. Whereas the intangible properties, we cannot determine its cost. Also, it is much harder to determine. So here, our patents, which we are going to discuss, these patents comes under the intangible properties. So before going on to that, the property tangible or intangible, we had seen the difference. Now we will see what is intellectual property actually. So intellectual property is an intangible creation of human mind and it is expressed in a tangible form that is assigned as rights of property. You can see that inventions, literary and artistic works, symbols and designs, these all comes under the intellectual properties. So intellectual property rights are the rights which are given to the person over the creation of their minds, and they give the creator an exclusive right over the use of his invention for a certain period of time. And different types of IPR, if we see, that is a patent. Patent is a, what is meant by a patent, that is which is a right given for a particular inventions. And then copyright is which we will be seeing for literary works, some music plays, for films, those copyright will be given. And trademarks are the design like mark like traits, things which are which represents their business, their trade, like you can see the trademark of Tata. So these all comes under the trademarks. And then industrial designs means is it something related to the design patent, that is a particular design to a certain company water bottle. Those all comes under the industrial designs. And geographical indications represents that, suppose Assam tea, that is a tea which is grown in the Assam region, has a geographical indication that it is called as Assam tea. And we are not supposed to call any other place, if we are growing the tea leaves, we can't say that as a Assam tea. Only the tea which is grown in the Assam region, like Tirupati laddu, these all comes under the geographical indications. And trade secrets, that for that we won't go into any written form of IPR, but the trade secret is a, which is the thing which gives a certain, which is a secret which is maintained in that industry or in that company or in that family, in that family trade or something. What is it won't be in a written form in anywhere. For example, the flavor of Coca-Cola, it is a trade secret. No one knows except those who are producing that, that things. Okay, those all comes under the trade secrets. So, with this brief introduction on the intellectual property rights, now we are moving on to the definition of the patents. So, what is the first word patent? Patent itself means the Latin word patin. Patin means which we can open. So, a patent is an intellectual property right which is relating to an invention, is a grant of exclusive right for limited period provided by the government to the patentee. If you see in the definition, we can see that a patent is an intellectual property right. That is the first thing. And it is a grant of exclusive right. It is a grant of exclusive right. It is given, and it is given for a limited period and provided by the government to the person who is applying, that is the patentee. And the term of patent, if you see, as per the TRIPS agreement, India is also following the TRIPS agreement, and the term of protection of Indian patent is 20 years. This comes under the section 53 of the Indian Patent Act, and there is no possibility of renewal of the patent. The patent period is 20 years from the date of filing of the patent. And what is the need of patents? Why we have to go for patent? What will happen if we are not going to patent? So actually the patents are essential for various reasons in the perspective of an inventor or for the business or a broader society. For example, in the perspective of inventors, the patent will give protection of intellectual property. That is, the patents will be protecting the inventor's original work from being copied, used, or sold without their permission. And it is giving exclusive right for a usually that is for 20 years it is giving an exclusive right, and it gives monetization, and also it is an incentive to innovate it, as the inventors are spending a lot of time and resources for developing an invention. It will be encouraging the inventors. And in the perspective of business, if you see, it is a competitive advantage, and it will be attracting the investors, and it is used for revenue generation. By licensing they can generate the revenue, and it develops a brand value, company's brand value it will be developing. And in respect to the society, it will be encouraging the invention and the dissemination of knowledge. Sometimes inventions, if it is not disclosed, the society will be affected. Okay, and then the economic growth of the society, for the economic development, for the technological progress also, the patents are very much needed. And then in the legal and strategic needs, if you see, that is enforceability, that is a limited resource to protect their invention legally, and also for the market leverage, and also for deterring the infringement. So on whole, why we need the patents is that is a main mechanism for fostering the invention, protecting invention inventors rights, and driving economic and societal progress. And coming to the Indian Patent Act 1970 and the rules 1972 will be there. And this is a landmark in the Indian patent system. Actually, in the British time, there is a 1911 Act regarding the patent system. And then in the after the independence, the Indian Patent Act was introduced in 1970 and thereby rules in 1972. And what are the key features of this Patent Act 1970? If you see this, the main features of the Patent Act 1970 is it excludes the product patents for pharmaceuticals, agrochemicals, and food products. Actually, before that, the product patent is allowed in the sectors of pharmaceuticals, agrochemicals, and food products also. Now, in the Act, the Patent Act 1970 excluded the product patent in these products. Only the process patent we can apply in the field of pharmaceuticals, agrochemicals, and food. And the reduced patent term, that is here actually the patent term also from this 14 years for other inventions and 7 years for food, chemicals, and drugs is there. And then the Indian Patent Act 1917 had enforced that the patents will be having 20 years, and allowed compulsory licensing to ensure public access to essential products. We will be learning about the compulsory licensing in the coming videos, and this compulsory licensing is very important regarding the society benefits. And this act promoted self-reliance in critical industries like pharmaceuticals. And this Indian Patent Act is divided into 23 chapters, and the sections 162 sections are there. And coming to the next part of the patent system, that is, what is patentability criteria? What types of things we can go for patent? So the invention must fall within the scope of patentable subject matter, which is defined under the Patents Act 1970. So it should be under the patent subjectable matter as defined in the Patents Act 1970. So the fundamental principle of the patent law in India is the patent is always granted for an invention. Here the three things we have to remember, that is, it should be novel, non-obvious, and usable. That is, an industrial application should be there. Okay, if any of these criteria it is not matching, then it does not comes under patentable invention. Okay, so the three things: novel, that is novelty, non-obviousness, and industrial application, which we can also call novel, new, non-obvious, and usefulness. And before on moving to the what compounds or what things are can be patentable, what are patentable inventions, just we shall have a brief idea on prior art. Prior art means if an invention is described in a prior art, a patent on that invention is not valid, we will be seeing. So that is the prior art, as the name represents, prior information which is available to the public in any form before the given date where they had claimed the patent virginality. Before that given date, if the invention is in any form, then we will be calling it as a prior art. That is in before the filing date of the patent application, if there is any information available in the public regarding that invention, then we will be calling it as a prior art. And coming, what cannot be patented in India? So the Indian Patent Act 1970 will be specifying certain categories of inventions cannot be patented. Apart from the thing, that is the patent should match the novelty, non-obviousness, and industrial application. And then which types of categories of inventions cannot be patented, also the patent system had given. Apart from those non-patentable inventions, all the other can be patented it represents. So the categories of non-patentable inventions are mentioned under the two sections, that is section 3 and section 4. Section 3 and section 4 are the very important sections which gives a preliminary idea to a person who is going for patent whether his invention is patentable or not. We shall see deep into the things which comes under the section 3. First of all, the frivolous or contrary to natural laws. The inventions which are frivolous or which claim something which is obviously contrary to the natural laws, that's a type of inventions cannot be patented. It comes under section 3a. Here I am representing the sections. If it is useful for you, we can remember. Otherwise, just to have an idea, you can learn which are not which cannot be patented. Okay, for example, for the section 3a, which is contrary to natural laws, for example, a perpetual motion machine, that is violating the laws of thermodynamics. Here thermodynamic laws are being violated, so it cannot be patented. Next, coming to the second, that is contrary to public morality or order, that is which is causing some harm to humans, animals, and plant life. For example, biological weapons or process of cloning humans, those cannot be patented. That comes under the section 3b, which causes harm to the humans, animals, or plant life, contrary to public order and morality. And then coming to the third, that is mere discovery, 3c. 3c is the mere discovery. Discovery, you can remember 3c, c represents the discovery, c. So the section 3c, here the scientific, the mere discovery, which is discovery means which is already existing, that we are reporting. So for example, a mere discovery of a scientific principle or abstract theory or a natural phenomenon, then we will be calling that as a mere discovery, and it cannot be patented in India. For example, discovery of gravity. Gravity is already existing. The discovery of gravity or a natural occurring microorganism, those does not comes under the mere discovery. That is this comes under the mere discovery, and this cannot be patented in Indian patent system. And moving on to the next, that is a new form of a known substance without enhanced efficiency. Already the substance already it exists. If we are using the new use for that substance, but there is no significant efficiency, then it cannot be patented. For example, a drug is there. So the drug is actually in a powder form. For example, think of, now we are going into the crystalline form. Okay, crystalline form of a known drug we are framing, but it is not having any improved therapeutic efficacy. If it has an improved therapeutic efficacy, we can go for patent. If it is a new form of a substance with improved therapeutic efficacy, then we can go. But here what is the case? That is, it is a a different new form of a known substance, but there is no improved therapeutic efficacy, then it is not be patented as per the section 3D. And then and you can see the some cases also, we can see those in the discussions. And then coming to the next part, that is section 3E. Section 3E represents mere admixture, that is admixture, a mere admixture resulting in aggregation of properties rather than synergistic effects. So for example, we know the the properties of those substances, just we are taking the A substance and B substance and we are mixing it, that is AB mixture we are forming. That mixture, that mere admixture cannot be patented in India. Okay. And then coming to the section 3F, that is arrangement or rearrangements. For example, a known devices are there, just we are connecting two known devices, for example a fan with a clock, like that, just we are rearranging the circuit, those things cannot be patented as per the section 3F. And then the methods of agriculture or horticulture. The method of agriculture and horticulture cannot be patented as per section 3H, which we can remember H represents horticulture. Okay. And then coming to the section 3I. 3I, I represents, that is a process involving medical, surgical or therapeutic treatment. Here we have to note that a method of treatment for humans or animals cannot be patented, whereas the devices which are used for such treatments can be patented. And next coming to the section 3J, here the plants, animals and biological process. Inventions which are relating to the plants and animals in whole or any part of that, thus cannot be patented. So for example, genetically modified plants or animals cannot be patented, whereas a new invention of microorganisms, development of microorganisms by genetical modification, that can be patented. That we have to have an idea. Genetically modified plants or animals cannot be patented, excluding the microorganisms. So here you may had a doubt in the before, that we had said in the mere discovery of the known naturally occurring microorganisms which are already present cannot be patented, but the genetically modified plants or animals in that category, excluding the microorganisms. So microorganisms which are developed novelly can be patented. And the next mathematical or business methods, algorithms, computer programs cannot be patented as per section 3K, that is the software programs which are not having any normal technical effect cannot be patented. Computer programs cannot be patented. Next coming to the literary, dramatic, musical or artistic works. So these are also cannot be patented as per the section 3I. And the mere scheme, rule or methods, that is as per section 3M, that is for playing a new method in playing a game. For example, a new strategy in playing cricket or a new strategy in playing chess, those cannot be patented. And next coming to the section 3P, which is a very important section, that is a mere reproduction of traditional knowledge. For example, we know that turmeric is used for wound healing from a many from a time, from an ayurvedic time, that is many years we are knowing. So we can't go for patent, that is for turmeric, that it is having some wound healing effect, like that. That is herbal remedies which are known in ayurveda cannot be patented. That is a traditional knowledge. If it is reported in the traditional knowledge, it cannot be patented. So, and the next, the last section 4, these we had seen what all comes under the section 3, and now coming to the section 4. Here also this section 4 also talks about what cannot be patented in India, that is the inventions which are related to the atomic energy. So the inventions which are related to the atomic energy are not patentable in India. So the process or apparatus directly linked to atomic energy production, such process or apparatus, those all cannot be patented in India. That is section 4 represents the only one thing, that is atomic energy related inventions are not patentable. So these exclusions reflect the India's balanced approach towards the patent law and ensure the patents are granted only for the genuine inventions, and taking into public interest and technological advancement, and also safeguarding the traditional knowledge, public health and morality. Okay, that's all about this topic of Indian patent system introduction, and what are the patentable and non-patentable inventions. We shall see about the types of patent applications in the next video. Thank you.